We're very lucky to have Associate Professor Alice Lee with us. She's visiting for a month from the University of Hong Kong, and we'll continue with the introduction.
Yes, thank you so much, Julia. Thank you. It's really my honor to be here, to be able to visit the faculty, the center, to meet Professor Bentley and Julia and Eleonora and other members of the center. Thank you. So once again, may I take this opportunity to thank Professor Bentley for helping me with the application that I made months ago. It was actually over the summer vacation that I applied for this Hughes Hall University of Hong Kong visiting fellowship, and so it was with his assistance that I was able to get the Law Faculty Board's endorsement. Thank you so much. Thank you once again. And when I picked the topic, actually I was wondering, would this be something of interest to people who are teaching, studying here? And I was relieved because I ran into a bunch of my former students. They are, of course, from the University of Hong Kong. They have completed the university, the undergrad degree at Hong Kong U, and now they're doing their LLM, and they are taking Professor Bentley's intellectual property class. So I thought maybe they will make my talk more relevant now, because I will be talking about the consultation in the United Kingdom and that in Hong Kong. And I've chosen this topic because I happen to see some very interesting similarities between the two exercises. So I don't know whether it is pure coincidence or maybe because we people in Hong Kong still have the tendency of following closely what's happening over here, and that's why we happen to have the same stage of consultation in relation to copyright reform. So we'll find out maybe later. So by way of introduction, because I learned from my former students that actually they haven't done copyright yet, and they are new to this topic of parody and copyright. So hope you don't mind if I start with some very basic introduction like this. Of course, this is about the consultation in the United Kingdom, and it's been going on for a number of years already. Started with the Gower's review in 2006. And then there were further reviews, further consultations, proposals. And this is, I believe, one of the documents that the people at the Hong Kong Intellectual Property Department office have looked at, because I could see some striking similarities between the two approaches. For example, here in the UK, you have looked at the treatment of parodies in 7 jurisdictions, whereas in the Hong Kong consultation document, which I will be showing in a few minutes, you will see we are also looking at the consultation in other countries, including United Kingdom, United States, Australia, and Canada. So we looked at 4 jurisdictions. Now, why 4 instead of 7? Because we are not really interested in France, Germany, and the Netherlands. For a very obvious reason, we're not part of the European community, and so we're more interested in places like United Kingdom, Australia, Canada, and also the United States. So that was one similarity already that I have spotted. I mean, the approach to the consultation basically is to, first question is, should we legislate? And secondly, if we do, then which model we should adopt? Should we, say, have a fair dealing exception for parodies? And if we do, how we define the scope of the exception? Should it be just parodies, or parodies, caricature, prestige, and so on and so forth? So the scope of the exception was also something that we in Hong Kong looked at. And I think the exercise is quite similar over here. And I've actually done a little bit of research on the UK consultation, and I happened to come across this document where it actually is a very short, nice summary of the views supporting and also not really supporting the proposed exception for parody as such. And the reasons are also very familiar. We have similar reasons for and against the exception in Hong Kong. So for those who are supporting, they would say, of course, it would be encouraging the development of free speech, fostering of creative talent, and it will benefit the educational sector. I believe these factors would also be relevant in other jurisdictions such as Hong Kong. But for those who are against the proposed exception, then they would say, well, parody is actually another kind of industry. So people can actually make money by doing parodies. So why should they be exempted from the duty to pay royalties? They should also pay in order to use other people's work, in order to recreate. So there are actually pros and cons that we can't really say who is right and who is wrong, because they are all making their points. So I can just see that these are the arguments we have also been hearing in Hong Kong, and I believe in other jurisdictions as well when they were having their consultation. And I don't know whether this is the latest development in the United Kingdom, but I saw this document saying that there is actually a draft provision. Is this the latest then? It's a draft provision proposing that it should be a fair dealing exception. It's a very simple draft, just using the word parody without the other parody, caricature, or pastiche, but without really elaborating on the meaning of each of these words. Now, this is another thing we actually had a debate in Hong Kong, because when we first started our own consultation in Hong Kong, probably the people, they were really concerned, and so they asked the government in Hong Kong to consider defining these very interesting terms like parody, caricature, pastiche. But the people at the Hong Kong government kept telling the general public that it's almost impossible to define any of these terms, and that it is tradition, either in Hong Kong or in the UK, that we just use ordinary dictionary meaning, and that would be good enough. Because if we try to define any of these terms, then we are actually limiting instead of broadening the scope of the exception. And if what they want is a broad exception, then we actually told them that they should not be asking for a statutory definition. Unfortunately, the people in Hong Kong did not seem to actually buy this point that we were trying to make. In other words, they were really pushing for statutory definitions. They thought that would be the best way to secure the freedom of expression. They thought if there is a list of things they can do, which is in black and white in the statute, then they would have the peace of mind. They would know whether or when they would be caught by the law. So that's the background for the benefit of those who haven't done copyright yet. And we have almost a parallel development in Hong Kong, I would say almost parallel. And before I looked at the Hong Kong consultation, then for the benefit of those who are working here, maybe I give a bit of introduction to the Hong Kong copyright system to show you how similar it is to the one in the United Kingdom. And it is actually more than similar. I would say, because when we did our own copyright ordinance back in 1997, I'm sure that the Hong Kong government actually looked at the UK CDPA 1988 for reference, and you could see it's almost identical, can I put it that way? To copy, issue copies, rent copies, make available copies. Now, the only thing we haven't done yet is this one, paragraph F, to broadcast the work or include it in a cable program service. I know that in the UK you have already adopted the broader language communication. But we haven't. And this is exactly the point that we were trying to make when we introduced our consultation paper. We said to the public in Hong Kong that we are lagging behind because all other major jurisdictions have already modernized the copyright law. They have used the new terminology, the right of communication, instead of broadcasting or cable program. You see the technology is very different. Broadcast, cable program, they are actually outdated now, I mean, in terms of copyright legislation. So this was the actually background to our own consultation in Hong Kong. We were trying to push forward a much broader right of communication. Hopefully it would include everything, including broadcasting and cable program. So this is where we provide the civil liability for copyright infringement. This is section 22 of our copyright ordinance, which I would say is very similar to section 16 of the CDPA. Very similar, if not identical. And how about criminal liability and also secondary infringement? Now, this is our provision, our section 31 in Hong Kong in the copyright ordinance dealing with secondary infringement, possessing for the purpose of, or in the course of trade, let, sell for hire, and then exhibit in public, or distribute. Now, this one is a more problematic one. Distribute, otherwise than for the purpose of, or in the course of trade or business, to such an extent as to affect prejudicially the owner of the copyright, because this one does not involve any commercial, trade, or profit element, right? It's other than for the course, for the purpose of trade. So this will be things like people sharing something maybe on YouTube or I don't know, other social networking system, not for profit, not in the course of trade, but to such an extent as to affect prejudicially the copyright owner. And in Hong Kong, we happen to have a case where someone was actually prosecuted and found criminally liable for sharing 3 movies by BitTorrent, the technology, and he was not doing this for profit. I mean, he was not charging a penny for this, but he was so generous. I mean, he just uploaded through planting the seed so that other people can have access to the 3 movies. And he was actually prosecuted and he was sentenced to 3 months imprisonment in Hong Kong for doing this, not for profit. So it was actually quite I mean, people in Hong Kong, they were shocked when they landed, oh, I could get caught just by sharing something not in the course of trade on platforms such as YouTube or other social networking system. And so that's why the government in Hong Kong thought that, okay, maybe we need to modernize and to clarify the scope of the liability, because people in Hong Kong, they were really scared. They did not know whether they would be the next one being prosecuted for doing something similar. So that was another reason why we introduced the copyright consultation. And the last reason, as I've said, we are aware of the amendment in the UK CDPA, the section 20, infringement by communication to the public. This is exactly what we wanted to do in Hong Kong, to replace the older version, broadcasting and cable program. We thought this would be more modern. And also we want to be part of the international community because we are aware of the international provision that it's about communication to the public. So we thought that this would be the language, right, that would be preferred. So that was the background to, now this is the timeline of our consultation in Hong Kong. We have the very, I don't know, where is it an appropriate or a very fancy title. It's called Copyright Law in the Digital Era. That was the title of our consultation document. We started it in 2006, which actually was more or less the same time as the Gau's review, I guess. Maybe that was one of the documents inspiring us, I don't know. And so we have preliminary proposals 2 years later, and then we have concrete proposals 2009. And we actually came up with the bill, an amendment bill, 2011. And I was involved in the consultation because the Intellectual Property Department in Hong Kong, which is the equivalent of the Intellectual Property Office here, they actually ran a number of public forums in soliciting views from members of the public on the proposed reforms. And I also joined some of the public forums where I actually discussed the proposed amendments with different sectors of the community. So let me show you some of the proposals. So that is taken from chapter 2 of the first consultation document that we issued. And so this is explaining the background, why we wanted to introduce this new right called right of communication. Is because of the technological advancement. We want to catch up, and because of the international trend of modernizing copyright law. And also because you might be interested to know that actually in Hong Kong, both lawyers and judges, they are still looking to UK cases for assistance if they can. So that's why, in order to be able to do so, of course, they would like to have similar provision in the legislation. So it makes more sense. I mean, if the language is exactly the same, the provisions are exactly in the same wording, then it makes more sense for them to look to the UK decisions for assistance when they are deciding cases. So that's the background. And so their first proposal is what is stated here, that they would like to introduce a right of communication with criminal liability, but then there will be only criminal liability if the communication is made for the purpose of or in the course of business. So in other words, if you are just sharing something with friends, then probably you will not be caught by this new criminal sanction. That was the provision first suggested by the government. And then later on they thought, okay, maybe we should make it clearer. So then they had 2 paragraphs here. So there will be liability, criminal liability, if it is either in the course of business or if it is to such an extent as to affect prejudicially the copyright owner. Then people began to panic because they saw this phrase again. I have explained, in Hong Kong we have a case, we have a prosecution where someone was actually sent to jail for 3 months for just sharing 3 movies without charging.
When was that case?
That was 2007. So it was right at the time, yes, right before this document was released. So people were really shocked to see the same expression in the consultation paper because they thought, oh, does that mean the people at the government would be catching us if we are sharing something, even if we are not doing it in the course of trade? So this was the problematic expression that people in Hong Kong, they did not like. They asked the government to remove this. But on the other hand, you could say that we have also the copyright owners, the licensing bodies, they are saying that no, we cannot be giving in too much. I mean, if you just say for business, then how about people maybe uploading movies for free? But it would still be affecting the copyright owner. I mean, if you are not charging, indirectly, you would still be affecting the profit. So we want to make sure that that is in the legislation. But that was the main opposition. So with that in mind, then the government came up with the idea, okay, maybe then we can clarify a little bit what we mean by to such an extent as to affect prejudicially the copyright owner. This is the phrase, right, that was causing a lot of problem. And so the government, the next step was they tried to elaborate in 5 factors what they mean by prejudicial to the copyright owner. They thought this would be giving people in Hong Kong maybe some assurance that they would not be really prosecuted. Now, so these are the 5 factors that they included in the bill. This is the amendment bill of 2011. So the 5 factors, they are very common, usual factors like purpose of the communication, nature of the work, including its commercial value, the amount and substantiality of the portion taken, the mode of communication, and any economic prejudice, including effect on the potential market. So we thought, well, this is something common. I mean, commonly seen in any copyright legislation. So people would be happy, should be happy with this. But it turns out that no, they still thought that this is not clear enough. I really don't know what they were asking for because they thought, no, this is not good enough. They want something much clearer, such as a clear, explicit exception for things like parody. They thought, parody is not mentioned here. So that means if we are doing things like making fun of someone, a politician, we upload it and share it, we might cause some, we don't know, prejudice one way or another to that person. Will we be caught then? So still, people were not sure about the effect, the impact of this piece of legislation, proposed legislation. So this was the bill back in 2011, and unfortunately it was aborted because the government in Hong Kong did not manage to solicit majority support for this piece of legislation. Now this is an example I want to share with all of you, and this is, I think you will be familiar with this, Avengers, a movie, right? And this, those from Hong Kong would be familiar with the faces. This is our chief executive, which is the equivalent of our governor back in when we were a colony. And then the other, they were the senior officers of the Hong Kong government. So when the amendment bill was put forward, then people in Hong Kong, they tried to make fun of all the government officers and say, okay, how about this? Will this be caught by the proposed legislation? So they have been doing this every day, I can say every day, uploading it and then asking the government. So tell us, will we be caught or will we be exempted? So they were actually pushing for a parody exception, using this as, I don't know, an example, and it is done every day. So, so this is, I don't know how one would classify this. Is it parody? Is it satire? I don't know. Is there a way of, they do overlap, I guess. If it is supposed to be funny, then it will be parody. If it's supposed to be critical, cynical, or skeptical, then it would be satire. But it could be both, isn't it? So people in Hong Kong, they really reacted very strongly to the proposed legislation, saying that they want more certainty in the law. They want to know what they can or cannot do. So tell me, is this infringement? This is what they want, a yes-no answer from the intellectual property department in Hong Kong. But no one in the government was able to say very clearly this is or this is not, because they will say, well, it's to be decided on a case-by-case basis, and it is to be decided by the judge, not by us, because we are just the people doing the consultation and also the drafting of the legislation. But in the end, it's the judge, right, who would decide whether something is infringing or not. And there is another example I want to show, again, from Hong Kong. This is not about the government. This is about a real estate investment trust managing a lot of properties in Hong Kong. So in Hong Kong, we have not only an anti-government sentiment, we also have a very strong anti-property developer sentiment. Yes, all the successful developers in Hong Kong, they are the targets of parody, satires, and every kind of innovative work. So this is another example. Actually, this is the original poster. And in the parodied version, they actually changed the title to something which I would say is very strong language. That's not appropriate for the audience here. So that's why, why people in Hong Kong, they were doing this every day, because they wanted to push the government to give them a very clear yes-no answer. Can you give us a list of things we can do or cannot do? And just one last example. This is the logo of a political party in Hong Kong. But these three Chinese characters, they are not the original Chinese characters of that political party in Hong Kong. So those who understand Chinese would know they are three virtuals. And the fourth one is missing. So there are four, I don't know how to put it. Is it four virtuals? Should I put it that way? Right? So the implication, why they're changing the Chinese characters here, now the logo is the same, they just changed the three Chinese characters here to make an implication on that this political party is shameless. This is the message they wanted to say by this version of the logo. And actually in this case, I think the customs department, they did seize all the t-shirts, but in the end they did not really charge anyone for making this available. But you can see that this is the environment that we have been having in Hong Kong in the past, I would say 5 to 10 years, that people, they are protesting, going onto the street every week. Every Saturday and Sunday. The streets in Central and Admiralty will all be blocked because people, they were protesting either for this or for that. So they are all trying to make their political statements. They are all very eager to do so, either one way or another. That's why I think there is a kind of a change in the environment in Hong Kong. The people, they're more outspoken now. They are more willing to express their views. And so that's why so many people in Hong Kong, they were against the introduction of the right of communication provision, because they thought if there is no proper explicit exception for parody, then they thought that their freedom of expression would be prejudiced. That was their impression. So that's why they were fighting very hard for an explicit parody exception. So remember I said the 2011 consultation was aborted because it did not say anything about parody. It was not even mentioned in the proposed bill. So it was scrapped. And so now, this year, July 2013, this is the website of the Intellectual Property Department of Hong Kong. So they have put forward a brand new proposal, which is completely different from the former one. And I would say this one is much closer to what you have seen in the UK. This is where they compare the 4 jurisdictions, UK, United States, Canada, Australia, to see what's been done elsewhere. And parody, the word finally was included in the consultation. So I thought the people in Hong Kong, they would applaud and say, oh, wonderful, we finally got what we have been asking for. Actually, no. When the government gave them parody, they thought, this is not good enough, we want more. Because they realized that what they are doing might not fall within the strict definition of parody. They might be just attacking someone, not really in the form of parody, maybe something else, something different. And that's why in Hong Kong, in our discussion, someone has come up with this term, which is not very accurate, I must say, but this is the term that people in Hong Kong have been using in their discussion in relation to parody and copyright. And this is the term, it's the translation of a Chinese term, secondary creation. Actually, in Chinese, we are trying to say creating for the second time. And so we translate that into English, it becomes secondary creation. But then we realize that, well, this is not a commonly used term in copyright discussion, so it's kind of confusing, and people might not know what we are talking about. So that's why the government on their webpage made this very clear in one of their frequently asked questions, that the consultation is on parody, not on secondary creation, because this is a term which is much broader. It includes almost anything that you recreate, whether it is funny or not, whether it has any comic effect or not, whether you are commenting on something or not. So it's basically just reusing other people's copyright work. That is what we mean by secondary creation. So you can see when the government give in and give them the word parody, then people in Hong Kong say, no, parody is too narrow, it's just one word. We want everything, parody, satire, prestige, burlesque, and secondary creation, which means everything, which means we can do anything, because they said they want the best protection for their freedom of expression. And so, in my final slide, you would see what is the latest stage in our consultation exercise. Now, this is the latest document, just released a few months ago in Hong Kong, 2013, this year. And so you can see, this is kind of mirroring, I think, the UK consultation paper, because they started with the four words, parody, satire, caricature, and prestige. And they also mention overseas countries, Australia, United States, Canada, and the United Kingdom. Actually, we have looked at all four jurisdictions to see whether we can learn anything from them. In this next paragraph here, the government was trying to explain once again there is a remarkable difference between parody and what people in Hong Kong call secondary creation. This is not just too broad. It basically is anything, any reuse of other people's material would be what we call secondary creation in Hong Kong. And so in order to actually explain the new stage of the consultation to the public, the government has been doing another round of public forums. So this is just one example. Just a month ago, November, so this is a panel of the Legislative Council where people, members of the public, they can express their views, they can attend the meeting, they can also submit written documents to say why they support or deny or why they are against the government's proposal. Now, this is the last slide I would like to share with you. I'm sorry that it is in Chinese, but I've chosen this because I've met all these people in the public forums. I can tell you they are really hostile people. They were almost going to fight when we tell them that it's fine just to have the word parody because it's just an ordinary English word. We will be able to sort out what's meant by parody on a case-by-case basis. But then these people, they are the so-called parodists. I think they hold themselves out as parodists. They said, this is not good enough because what we are doing is much more than pure parody. I mean, sometimes we do this for fun, sometimes we do this for another motive, maybe to criticize the government, to express maybe our view on something which is not necessarily funny, not necessarily falling within the scope of parody. And that's why this is the last public forum that I attended, November, again, which overlap with the government consultation. And so they're asking for, now this is a Chinese phrase, which means the fourth proposal. Now, then I want to explain what the government is trying to propose right now, and they are now asking for a fourth proposal. So, currently, the government in Hong Kong are considering three proposals. Firstly is to just leave it as it is, that is, to use the phrase to the extent that is, maybe I can show you once again. So that was, there are three proposals. The first proposal is to just leave this phrase to such an extent as to affect prejudicially the copyright owner in the legislation, because it's already there, it's an existing provision. So the first proposal is, okay, we leave this in the legislation, but maybe with an elaboration. just like what I've shown you, right? So maybe there were 5 factors that are here, right? So this is proposal number 1. Leave the phrase in the legislation, but we have a list of clarifying factors, right? So this is the first proposal. Second proposal is, no, we insert the word parody into here and say, okay, if you are doing this, even if you are communicating the work to the public to such an extent as to affect prejudicially the copyright owner, if you are doing this for the purpose of parody, then you will be exempted. So in other words, the second proposal is to have an explicit exception for parody under this situation. That is the second proposal. And the third proposal is just like what you have in the UK right now, to include a new fair dealing exception just for parody, or maybe as many words as they want, maybe parody, satire, pastiche, so on and so forth. So that would be more similar to the UK and I think Australia approach as well. Now, they thought none of these 3 is good enough. After all these years, I think we've been doing this for maybe, 5, more than. After all these years, so they are saying that no, even if you use the word parody, it's not really comforting. So they are asking for a 4th proposal. And actually the 4th proposal is very similar to the Canadian approach, which is also mentioned in the UK Consultation document. So the Canadian approach is to have a standalone exception for user-generated content. Because if they use the phrase user-generated content, then it doesn't really matter whether it is parody, whether it is funny, whether it is commenting on something or not, it doesn't really matter. More important is that it is non-commercial purpose, and then you acknowledge the source. And so the same criteria as those listed in section 29.21 of the Canadian legislation. So this is the latest proposal in Hong Kong, because people in Hong Kong believe that this will give them what they want. Basically, they want a blanket exception, which does not require parody or any other specific element. But this is just their proposal, not from the government. I don't know whether the government in Hong Kong will be listening to them, accepting the 4th proposal, or actually someone else in Hong Kong suggested, why don't we have a combination of all these proposals, a bit of everything, and I still don't know what will happen because this is still ongoing. So this is what I can share with all of you, and I hope we can have some time to discuss what is the way forward. I would really like to hear from you what's going on right here. Is it the same, or you have already sorted out what you want to be inserted in your legislation? Thank you very much.